Lord, may I be permitted to mention one matter, item number 49. This is a matter, an appeal filed by the state against an order and judgment in which I succeeded before the trial court.
Yes.
And the judge is Honorable Justice Partha Chatterjee. And I got an order in my favor whereby Honorable Court directed the concerned authority to give me appointment. But within a particular period. That did not done. Then that was not done. But I could not file an application for contempt as because the judge is not available all the time, because as and when his lordship will sit singly, it will be hard.
Correct.
Now state has preferred an appeal. And that appeal, it is shown that it is a defective appeal. So my submission before your lordship, if your lordship...
Wait, don't worry, we'll take up. Applications we are taking up today, don't worry.
Oh, deep.
My lord, may I be permitted to mention one second appeal? I've served notice. We are the
Second appeal, we don't have a determination. Is it order 41 or
Yes,
what?
order 40.
Say that order 41, second appeal.
I'm sorry. I
Yeah.
apologize.
May I be permitted, your lordship, one contempt matter, your lordship.
Of this bench,
It's your lordship and Honorable Justice Shampa Sharkar's bench.
Pampa,
Shampa Sharkar, Honorable Justice Shampa Sharkar's bench.
একটু কথা বলো। Yes, call.
Item number 1.
My lordship,
My lord, I am appearing, my lord.
to take up the
My lord,
application
I am appearing only.
under compelling circumstances, I would like to state that Senior Counsel Mr. Anit Rakshit is unable to attend today. So it's
Council.
yes. So if you could kindly
My
take
lord,
up
is item number 1. I
Item
think
number
he's,
10.
Mr. Onuranul Samanto is appearing, my lord, online. My lord, I am seeing.
Yes, my lord, it's not appellant, my lord. You must be wrong in some.
for the appellant.
My lord,
No, appellant
know
is
what-
appearing, my lord.
He was item number 10. I told him. Item number 10 under
We
application.
have called item number 1, sir.
Yes, yes. That's why I stated under compelling circumstances. If you could please.
Please let it be called first.
Okay,
Let
sure,
us
sure.
see.
Thank you.
My lord, I have mentioned this matter for some typographical mistakes, my lord, in the order, my lord. My lord, kindly takes up the order, my lord, from first paragraph, my lord. My lord, the order dated 26/11/2008, my lord, it should be 14/9/22, my lord.
22.
Yes, my lord.
14 September 22.
Yes, my lord.
14 September 22. Nandito.
My lord, and subsequently, my lord, miscellaneous case number 8 is for order 9, rule 9. It should be, my lord, miscellaneous case number 20 of 2003, my lord.
এখানে এই দেখো এটা 14 September 2022. It
My
will
lord,
be
and at the last line, my lord, miss case number 8 of 2004, it should be miss case number 20 of 2003, my lord. My
yes.
lord. And my lord, in the 5th page, my lord, 5th page, my lord, paragraph 16, my lord. Kindly, my lord, takes up paragraph 16, my lord. From whatever angle we look at it, does fit, my lord. It should be does not, my lord. My lord. What I think, my lord. My lord, rejected.
It should be not.
Yes, my lord. My lord, that's all, my lord.
Huh? এখানে does not হবে ঠিকই আছে কেন অর্ডার সব সেট অ্যাসাইড করছি
Yes. Oblige, my lord. Oblige.
call the next
Item number 2.
But item number 2, my lord, I appear for the respondents, my lord. This is an appeal, my lord, against my
We
lord,
are for the
order of-
appellant opposite parties
my
in
lord,
this
the
application.
decrees of preliminary decree, my lord, in a partition suit, my lord, there has been mistake in calculation of shares, my lord. Rather, we will be conceding to the prayer of the appellant, my lord. And my lord, we have prepared a chart, my lord, regarding the shares, my lord. My lord,
so let us fix a date you can
No,
come,
it is not. I think that it was possibly
but this was
jurisdiction of not Possibly for modification purpose, this particular case has come, this particular application.
You are for the
modification application,
appellant
we are
or
not-
you are for the respondent?
I'm for the respondent.
I'm for
Respondent.
the appellant. This is for the appellant.
I'm for the appellant,
Correct.
opposite parties.
What he says is that you have challenged the preliminary decree on the ground that the shares which has been decided or declared by the trial court is not correct. He says that whatever the share you said that you have, he is conceding to it. And the degree will be modified in that. So your prayer is taken care of. This
My
is what he
prayer,
claims.
my lord, whatever maybe I'm to say. Now, my lord, let us come to this very particular narrow pedantic cabin crippled, my lord, the application which
What
is
is
they are
this?
placing.
These three words?
My lord,
Narrow,
what?
pedantic,
Pedantic,
pedantic.
cabin and crippled application.
the
They are,
third?
we are prepared
What is the
here.
third? Narrow, pedantic and
Cabin crippled.
cabin.
This application, cabin and crippled
Cabin.
application. Crippled
Crippled.
application. Before your lordship, they have,
Crippled.
my lord. Kindly, my lord, that if your lordship,
No, it is neither, it may be a narrow compass, pedantic, no.
my lord,
Cabin, no. Cabin is
My
large,
lord,
sometimes
my lord, I am
cabin is
saying, my lord.
small.
My lord, let me submit, my lord, what he is saying, my lord. My lord, the matter your lordship has already, my lord, what I am to say. Your lordship has already, my lord,
The client is present in court.
my client, my lord, there be so many clients. It's the Sarab's building. It is the Twin Tower, the so-called bypass, my lord. It's a crores rupees properties. Make it here.
Mr. Adhikari, when I am asking you
Our
the
client,
question,
I do not know.
is he present?
Oh, yes.
Then you have a justification in making your
It
submission.
is that. My lord, that I am to say. My lord, one thing.
We are fixing a date.
My lord,
Yes.
my lord, one thing. My lord, one thing.
How can you stand in the way of
My
fixing the matter?
No, my lord, what I am saying.
Sorry,
My lord, what I am saying, let the modification application, what they are saying.
not necessary, just civil law. Yeah, some.
Yes, my lord, I am leaving everything before your lordship. My
The
lord.
matter has come up by way of an assignment from the office of the Honorable Chief Justice. On the consent of both parties, let the appeal be listed. Tell us the date, we will fix on that.
Your lordship.
ওইদিকে কাগজ
অ্যাপ্লিকেশনসটা ডাকো, হ্যাঁ কোনটা আমি করে দেবো বলে দেবো। হ্যাঁ, বললো যে আমি ওটা দেখে করে দেবো। Need not have to be predicted. Let's call the applications. We will dictate, don't worry.
Since the matter is your lordship said, whether I will.
She asked me to come up with a.
For what? Oh, you wanted to argue further?
Naturally. Because I'm without the armory. This point was taken up so sudden.
Anyhow, call Mr. Mitro. You want to argue? I can't deny his right of audience. Certain percent HS.
No, she was asking me with a query on the yesterday itself. It was restricted to only one, which was not, to be honest, it was not taken up even at any stage of this matter. It was only for the first time I'm hearing this, and it was from the bench itself. So in fact, if you actually go by the implement order itself, there was no statement with that particular query. And even his writ petitions, even on affidavits, there were no statements and no averments being taken on that score. So I've already taken instructions over the issues. I've already, since we are without the registrar, we are without the VC, can you give me some time to get hold of the,
What?
what was the situation? Now, we have restricted our prayers, we have restricted our screening for till 25. Out of 25 ABC, we have getting the same, and Lashi has found some of the papers are missing, which indicates that we are.
No, there is no paper missing. Your decision is very laudable. Your decision is there. It is an admitted position. They are also not saying that, yes, you have put a cap, 57% is a screening committee
Decision.
To shortlist the candidates. That you have, that's there.
Now, 57 out of what? That there lies the query. 57 out of
57 out of 3 components.
Three components.
Undergraduate, postgraduate. That's all.
that ends. Now, if is the root cause, that if you do not score an average of 57% out of these 3, you're not going to the second round. Now, here Lordship was of the view that why this particular PhD and net has.
Because the word is good academic record. This is what the word was, good academic record. And then once you fix the parameter of the good academic record or academic record, then whether you can subcategorize it.
Now, if a particular qualification, which is not at all necessary, can that come within the zone of academic consideration for that post?
Correct. Then the second query that comes, then why you have earmarked the particular marks for that qualification?
No, I can.
Under the academic record.
If you Lordship be with me on the paper book for once.
Yes, please. Because you have fixed, still we remember 7 marks for postgraduate. Why you have fixed 7 marks?
I'm coming.
Not necessary. It was not necessary at all.
That's the reason why I was of the view, Lordship may term it as superfluous. But that was not a mandate. That was not even for a moment. If Lordship kindly takes the pain to turn to the paper book for once.
There is no selection procedure under the law. Rules does not say what you will follow. Simply says that there will be a selection process. This is the eligibility criteria. There is a judgment of 2008 which you have cited.
As defined by the university.
You have cited where you have said that for the purpose of shortlisting, because there may be a large number of candidates. So it is within the domain of the selection committee to fix a particular benchmark to shortlist the
Categorize.
shortlist. Means eliminate the major one and restrict it to a very that you can do it. There is no problem. The Supreme Court has
Even if I give a
you can
pause,
shortlist.
we have only eliminated 50% out of it. 50% is
50, 40, 30, that is immaterial. Percentage is not
immaterial.
material. Your right to
Eliminate
shortlist, eliminate certain number
is
people
sacrosanct.
is there. Is there. Now, if you say as defined, good academic record as defined by the university, then there is some kind of a discretion left to you. No discretion. But the moment you have set a parameter regarding the good academic record, then in that event, can you done away with a component and choose the another component? Or you have to put a benchmark on the overall. Meaning there, what I mean is, the academic record, you have set 40 marks, you have earmarked for academic records to assess the suitability. Then 40 marks you have divided. 25 marks you have segregated for the
Basic academic.
basic academics. 8 marks you have set up for research or something of that.
That is available to everybody.
SET, LET.
SET, that is available to
LET.
everybody. Everybody is getting 8. Everybody is getting 8. There cannot be.
Have I said that somebody has not got 8? You can't. Because that is also one of the criteria that LET or SET must be there.
Must be there.
And then you have earmarked 7 marks.
Now coming, if you're
for
not.
this postgraduate. So this division of marks,
I'm coming. What's calling from your lordship's mind?
I would say the genre of the academic records.
Why?
And
Why?
then the species. You have chosen one species, left out the another species.
No, nothing.
No. You have made out a case of that nature also, as you say, you argue.
May I for a moment? May I for a moment? For a moment, if your lordship kindly turn to page 7, page 212 for once. I think I can. And yes, page 212, lordship kindly test.
Please.
Now, if your lordship be with me, no, if your lordship was kindly,
Tell me.
no, kindly don't lordship do not close your lordship's mouth.
No, not closing. It is still it's a wide open.
Wide open.
It is wide open.
Why? Lordship is banking on the reason why. Now, for a moment, if your lordship kindly turn to page 212.
Yes.
The order impugned, which speaks of the parameters required for the selection.
There is a wrong perception in the.
No.
It says what is
Consistent.
consistent.
I'm not banking on that at all. I'm not banking on that at all. Lordship, be with me for 212. This is the relevant qualifications as prescribed for the UGC. Now, let's read together why this was given in.
Yes.
Yes. I'm banking on this what Lordship was hitting on the other day with the non-abstantee clause. Nothing withstanding anything contained in sub-clauses 1 and 2. Now, 1 and 2 reads with that good academic record as defined by the concerned university, as I was reading on the other day. Besides fulfilling the above qualification, the candidate must have cleared the national eligibility test conducted by the UGC, CISR, and similar tests accredited by the UGC. Now, here comes the third point, which is important. Notwithstanding anything contained in the subclause 1 and 2 of this clause, such and such, who have been awarded a PhD degree in accordance with the University Grants Commission regulations shall be exempted from the requirement of minimum eligibility condition of net and slide. That is the reason why.
What does it mean?
Therefore,
What does it mean? Sir, sir, then it goes against you.
no.
What does it mean? Means they have said that you must secure 55% marks in the master degree. If you are an PhD graduate, then it says that that should be done away with.
No, with regard to net and slate, not with the academic records. Kindly
Read again.
notwithstanding anything contained in subclause 1 and 2 this clause, candidates
One is a good academic.
good
score,
academic,
55%
Right.
master.
right,
NET or SET, whatever.
who have been awarded a PhD degree in accordance with the University Grants Commission regulation shall be exempted from the requirement of minimum eligibility condition of net slate and SAT.
That is what it says, that minimum eligibility is 55% in the master's degree.
Minimum eligibility condition of net and slate, not with regard to the
Anyhow, they may not come.
Therefore, if a person is without net and slate, having a PhD degree, then only it comes with the zone of consideration. Here, this is not the scenario. Kindly read with me once. Kindly take the trouble. Kindly take the trouble. I know I'm paining from this side. Kindly don't take me, I'm a bit vocal. But kindly be with me for once. It says if you are armed with a PhD, net slate will be exempted. It cannot say that minimum education qualification, which has been fixed by the university, is to be done away with. No. Kindly read with me for once. But with my limited knowledge of English, what I've understood. It never says that it is stating that you can be anything. Since you're armed with a PhD degree, you can do anything. No. Because first of all, with regard to assistant professor, this is the reason I was taking your lordship to page 27 for once, which reflects the advertisement itself. The advertisement reads for all professor, associate professor, and assistant professor. The tabulation will be reflected from here. If you be with me for lordship, kindly be with me for once on page 27.
Still there, don't worry. It is not that we have not. Still, I can verbatim, I can say what is it.
But that is the reason why I was just beseeching before the court that I've already called for them. That if your lordship kindly grants me some time, so that can be.
No.
If your lordship is lordship isn't no, this time I won't be getting at least any chance to.
We gave you a chance.
No, that chance, it cannot be said to be a chance at all. The subsequent query raised from the.
Tell you my experience over there. I still remember, I never asked more than 1 day for my preparation. I put a question, I put a point, there was a counter thing that came from the bench. Frankly speaking, I was not aware of that.
No, nobody was aware, to be honest, yesterday. Lordship may have a look.
Then I said, please grant me these days time. Tomorrow, first matter, I will come and argue. Went back, prepared myself, came tomorrow, did them.
Here I am without the armory until and unless I'm being instructed properly in the manner. No. Because this is for the first time this is being raised. Even the lordship kindly go by the impugned order itself.
They
Impugned order, affidavits, and nowhere writ petition.
They raised this point because those were not disclosed at the time when the writ petition was filed. Because it was filed at a period of time when there was nothing. When the interview was called only for the selected candidates of 29. Then they came that why I should not be permitted to appear in the interview. They challenged. Nothing came out. You disclosed in your affidavit. They have taken a plea from your affidavit.
No, kindly have a look whether this point has at all been taken in their counters also. This is the first time this is being. That is the
Mr. Mitro who argues the matter.
No, I don't mind.
And when he says that I took that point, you were not there. At least you cannot say that he did not. And we have
to go by the sanctity of the order concerned.
Senior counsel.
I don't.
He will definitely.
No, I'm not on to that at all. But as far the order is concerned, there is no reflection of such.
That is what the lie.
Now, if there is
Then I can sit with you on a different podium and tell you many miseries which I suffered on that.
so better not on to that. What I'm on, if your lordship do allows me,
So happened.
that can solve the problem in a better note. Instead of going by this, we can resolve the issue on a better note, because this aspect is not such an hideous of a crime that to outstate a person for no reason whatsoever. We have segregated the marks till 25. And we have mentioned that these are the parameters required. Now, if there is a query from the bench, I honor to that, no doubt to that, because until and unless I come up with a proper instruction, because that's the first time I'm hearing this. And in fact, this was first time it is being raised because the impute order do not reflect anything of such. Kindly be with me for kindly understand my predicament also. So it can be resolved on a better note.
I tell you, Lordship, my lord, only two documents I relied upon. Insofar as your Lordship's observation is concerned, one document your Lordship has been pleased to observe, no. So far as the eligibility, so far as this at page 67 is concerned, your Lordship will pleased to observe that no, I will accept the university's position that 57% marks has been given. They are entitled to do so. So this is one of the points which, my lord, I am not going to press any further because your Lordship has been pleased to observe, page 67. And second point I took was that they themselves are saying at page 182 that the academic record 40. And 40 is, my lord, taking into account the HS, UG, PG, and
What are you talking about? What are you talking about? I do not know. The paper book must have been served to you much earlier. Come to page 229, the ground number 14 which they have taken. Have they not taken this point?
no, this point was argued by me, or no other point.
229.
And come to global, the 14, ground number 14. Read.
Learned judge should have held that the finding of the respondent was not shortlisted as to fail 57% marks, e.g., HS, UG, and PG as decided by the screening committee, where there is no justification for arbitrarily 50.
This is what the point is.
No. This is absolutely 57% of marks the screening committee has decided. There's nobody is questioning this.
They are taking that.
Which
this is
point?
Absolutely arbitrary.
That university is not in a position to.
Now they say, now question is of arbitrariness. We are
Arbitrary in what?
arbitrariness.
No, arbitrary in what? Arbitrary in fixing 57% of marks.
Correct. Arbitrary in which is what?
Where on earth they have been stated that this is.
Earlier line is average of HS and UG.
Yes.
This is what it
Fails
is.
to achieve 57% marks in average in HS, UG, PG as decided by the screening committee.
That is what I'm saying.
When there is no
They are saying that
justification,
it's arbitrary.
kindly, when there is no justification for arbitrarily fixing 57% mark without having, kindly read as a whole, without there is a statutory provision to support the same. What is meant by that? I couldn't understand.
I understood correctly, you could not understand.
No, kindly, I couldn't, to be honest, because the language speaks that these 57% marks.
Could not, no, this is what a specific ground taken. Ground number 15 also.
No,
to that.
Kindly be with
Ground
me
number
for
15 also
kindly
comes to
be with me for once.
Sorry.
The point which was taken by the court.
Ground number 18 is also there. Ground number 18 is also very clear.
This is being.
This is ground number 18.
Yes.
For that, the learned judge should have held that there was no basis for the screening committee. 57%
marks.
in average taking HS, UG, and
OG,
PG.
on a wrong reading of UGC. Where he is getting that? On a wrong reading of UGC regulations?
This is what an interpretation would come.
Now, let us go by the.
So you knew that this is a point which they took.
No,
You say it's a
can't be
surprise
with
to
me.
you. I'm countering to your submission when
Yes.
you say it is a surprise to me.
It
They never argued. They never
What?
took this point. This is the first time the bench has taken up. So that's why it really brings us.
now
a
kindly be with me.
the ground
Whether your lordship would
already
be
taken.
generally what is being meant. It is not meant to be interpreted in another way.
No.
Language
I
is
tell
to.
you very frankly, Mr. Banerjee, there are certain persons upon whom I have a strongest of confidence
And
that factually they will not say anything wrong.
wrong, right?
And Mr. Mitro is one of them.
True. I fully bow down, but
When he says that I argued, I would take it as a sacrosanct that he argued.
the language itself in the grounds do not reveal such.
Absolutely. Ground number 18 is clear. This is what I am asking you a question. How can you fix a 57% parameter based on HS, UG, and PG? MG.
It's that
How can you fix? When the academic records, you have said that it will include HS, undergraduate, postgraduate, then NET, as well as the.
no. Here I give it a pause. Here I give
So
the
this is
language
not the
itself
language.
is otherwise. That
You will interpret the language which you are saying. There's no difficulty. It's a question of interpretation.
yes.
We are permit us to dictate. Permit us to dictate. We will clarify that what does it mean. No difficulty.
If lordship has
what
already
will proceed
closed
and
your
what
mind,
will
there's no
proceed.
point of.
No, it's not a closer. Because I know what you are saying does not really convey from that language.
But to be honest, as per their language is concerned, the plain reading of the language, it says 57% screening committee is not permissible to fix. That I object.
What?
The language is such. They are of the view, as per their plain reading of the drafting is concerned, the screening committee is not permissible to fix 57% marks to scrutiny. On.
They have qualified HS, UG,
Yes.
and masters. This is they are saying that you are not permitted. You are not.
No.
permitted
If
to
we
do that.
segregate PhD, these are the things which are remaining.
Not.
How would you say segregating?
Activate.
PhD is not a mandate. Lordship is inducting that.
Your client is there in the court, I believe.
No, they couldn't. But that is the reason. Kindly
So at-
thrash me out on the next day. I don't mind. But at least I should have my conscience clear.
I'm recording your all submissions so that you may not have any kind of a dissatisfaction in your heart that my arguments have not been.
No, I'm not onto that. Lordship knows that there's a authority, statutory authority until and unless.
No, definitely. We are going by the records interpretation. That's all.
My argument was
That's all. We are not going anywhere on the factual instruction. We are going on the record. What transpires from the language used and what does it mean to me or to us rather? That's all.
So kindly allow me to file a written note of arguments.
Also.
We are recording your submissions, what written or notes of argument.
Ground number 24 also, your lordship will be specifically taken this point. I relied upon only 2 documents of the university. 2 documents, nothing else. My entire submission was that. That's why I submitted a short point involved.
As I said very openly, I knew that if you have not argued, you would be very fair to come and say.
No, I would have said so. This is the only point I did
And
not
when
argue
you
any
say
other
that I
point.
have argued, I take it as a sacrosanct, nothing more than that.
I am very grateful to your lordship. But then again, my lord, I'm sorry that my lord friend is saying that I did not argue the point. It is the only point here.
I am really surprised by your, I would say, the demeanor that you have not reacted in a manner
No. Why should I?
which I used to react.
No. But my lord, he is much junior to me in the profession.
I'm telling you,
I will not.
I would have reacted differently.
No, I won't do that. my lord.
It's your modesty, your sobriety,
No, no, he's always my.
possess. When you were not there, I think that he did not argue this. When he says that I argued this, the judge
Everybody.
may not have,
Yes, that's the.
judge may not have written, judge may not have taken those points in the consideration.
Well,
Maybe that's a lapse. That does not mean that he did not argue. When he say I argue,
Well, I tell your lordship what I did, told the learned trial judge. I just drew his attention to these points. I said that you just academic record 40. 40 is the HS, UG, PG, and my lord.
No, I will say
that is 25
I
and
am
plus
just
8.
recording his submission so that he may not have any kind of a, may I use the dissatisfaction is the, I think, very appropriate word, that my arguments were not taken into
But
consideration.
I can assure your lordship one thing, and I can also, my lord, assure my learned friend of one thing, that had I not thought that, my lord, there is some substance in this, I wouldn't have, my lord, come before your lordship. After, my lord, losing there, I would have advised my client that the university has taken a decision, accept it and don't. I only was aggrieved because university, my lord, deviated from their own norms. That was my grievance. I said the university couldn't have done that.
It is vociferously submitted by eliminating any sense that I have not considered any of the points.
So this tantamount to be a CAV one way.
Not tantamount to CAV. It will appear দিয়ে দাও,
Porshud.
as for orders.
Oh,
এটা
yes.
টাইপ করে আমাকে পাঠিয়ে দিও, আমি ডিকটেট করে দেব। এই তো করে রাখি।
Kindly don't take me a mess.
No, I have taken an exception. When you say that Mr. Mitro, who argues personally, and they say that it not. This is not.
I can't be
At least
specific.
the language would have been that perhaps it does not appear from the impugned order that this point was at all taken.
Maybe we
But
learn
once you
every
say
day.
that I have, then in that
We learn every day. There's a mistake being committed. Or after all, to err is human. Lordship. So,
no, it's not.
apart from that, kindly don't take me a mess.
Yes, call the next one. Applications.
My lordship, appearing on behalf of the appellant, as I said, my senior Mr. Anit Rakshit is ill today, so he was not able to attend.
This is a restoration,
I know, my lordship.
and you do not, and Mr. Lokit is the most veteran senior.
Exactly.
So what would happen to the client? The answer that would be given to a client.
My lordship, he was there yesterday till 4:30, but sadly he fell ill.
No, we don't mind.
Can you please
Not
keep
this
it
week,
next?
sorry.
Not okay. Thank you, my lordship. Obliged.
I appear for the
I have been informed that
every occasion, my lord, they are asking for adjournment, number one. Number two, my lord, this matter should be heard by the division subject to lordship's side. This should be this is a railway claim case.
Oh, how can we pick up? It has to be heard by the single bench.
I have been informed, my lord,
And
this is
And
mutually
previous
beneficial.
occasion-
Now it has to go to single bench. Hey, amendment এসছে না ও আমাদের কাছে
Yes, my lord, I have,
ওই motor accident claim and railway
I have that,
accident claims that will go to the single bench.
and I have that,
You have
there are hundreds of matter appearing code number 33 railway, and the amendment,
become a part of that full
Yes,
court
and one-
reference where the
another,
amendment was
one
done. It has to go to the single bench.
and subject to correction, and another should be, your lordship kindly peruse appellate side rules, my lord. Your lordship has said 18 something, my lord, now the Railways Act is, my lord, 1989. That should be amended, my lord, subject to correction.
That will be.
And only thing, my lord, this will go before the, in earlier occasions, my lord,
Railway claims matter.
I don't know, my lord. I have been informed.
The railway claim matter.
yes.
Though an adjournment is sought, the adjournment was sought on behalf of the appellant. But
I'm for the
For the
appellant,
college, respondent number 4 and 5.
but I'm for the appellant. The state was to see.
That's Roma Halder and Shopun Dotto appearing for the state, my lord. I am paying for short passover.
who?
Roma Halder and Shopun Dotto appearing for the state, my lord.
Here are they. Only thing is, they wanted to disclose that, what would be the quantum of gratuity that would be admissible.
Yes.
Where are they? Why they are not appearing? What short point it is kept?
My lord, I am paying for short passover, my lord.
What?
Lady passed over.
Next.
And 14, I'm appearing for the appellant, my lord. I mean, less by senior counsel, Mr. Thakkar, my lord. Unfortunately, he's fallen sick, my lord, because of the weather and all. He's lost his voice. I'm grateful. Grateful.
On this matter, appearing with the respondents to authority. Mr. Bari is appearing with the appellant.
Last time also he did not appear.
I'm for the statement.
Take it to. Are they appearing on all the occasions?
Yes.
Mr. Badi, Ekramul Badi is for the appellant.
The defective one. Oh, defect removed.
কাউকে দিয়ে বলেই দিন আমি তো আছি তো প্রবাদ দেয় এসছে আমি তো আছি তুমি বলে দাও
What is the matter?
বলে দাও তুমি বলে দাও একটা
Mr. Bari appearing on behalf of the appellant, his clerk, he is on legs, kindly make it not today.
Not today.
এই 16 এই 16 করবে
15 is not today.
আচ্ছা
Call the next.
এই তো ডাকছি এই তো 16
16 I've got the appellant.
ও তুই
What is the defect?
I have just not gone through.
You did not look at the list.
Yes, yes.
You find it is defective.
Before check up the matter.
Before check up 10:30 in the morning, what you were doing till 12?
প্রাইভেট রেসপন্ডেন্ট ও না এখানে চলছে
Section 5.
Section 5 I have been filed.
Have you served?
we are unarmed with anything
File your affidavit.
but সার্ভিসই তো হয়নি
Sir, I said in course of this week,
Sorry, be happy. Let them serve to your client.
no.
And that's better.
By tomorrow, I said by tomorrow.
You are appearing for all the respondents.
রিট পিটিশন হ্যাঁ তাই তো রিট পিটিশন রেসপন্ডিং বলছি তো তাই
No.
কি হয়েছে
You are appearing for whom?
সুনীল
It's not here.
yes Sunil is a party concern
Oh, yes. Main.
main
Oh, your application for contempt was allowed.
turned down
Turned down.
I'm making it a cut short
Then how?
no
See,
I'm coming there was a petition which includes around 30-35 candidates. I was the person who moved the contempt application. They were not being made a party or they have not been something like that. Maybe that point has been taken. So hearing me that contempt application was turned down without incorporating them as a party, without hearing them, they have been thrashed out. In fact, they have been on service.
why they are filing an appeal?
The main contents a repetition was moved by his client.
Repetition
Are you challenging the main repetition order or
No. I'm recalling the order passed in the writ application.
Recalling stood allowed,
Contempt,
flashing the writ petition.
in the
So
contempt,
therefore, his right is infringed after 12 years.
The cost action says the added contemners? That's why I'm asking you.
what happened, the writ petition,
That means the contempt proceeding.
in a contempt proceedings, a recalling was filed by the state respondents, the order passed in the writ application.
When we moved the contempt,
I was a party, I made an application for addition of party.
ওইটাই তো বলে
In the writ application, I was made an application for addition of party. That was allowed. In the contempt proceedings, sorry,
Contempt proceeding, what has happened?
In the contempt proceeding, I was not party, my lord. In contempt proceeding,
You're supposed to be a party.
in the contempt application, they file an application for recalling the order passed by in the writ application.
That means it should not be in the contempt application, or it should be there in the
No, no.
writ,
Contempt application was my individual contempt application.
and then find an application in the original writ for recalling the order.
No, no, no. This is not my recalling. Recalling gives from the state's end. Right. Therefore, when we move the contempt and recalling was heard together. And subsequently recalling the main parent order, which was passed 12 years back, flashing out all the appointments, contempt was also dismissed. Now they are coming with the scenario that they were not even party to the proceeding, since it was the contempt which was being moved. It was the contempt which was being moved for enforcing the order.
Come ready with the locus standi first. Then I will go into the different. When today are you ready to argue? Your locus standi.
No, no,
Well, since my lord, I was the party in the writ
Are you
application.
ready to argue? We will hear you on a locus standi.
Next day,
Not this week.
In the meantime, the defects be removed and a service be made. That would be better.
Call the next.
Great.
Yes, next.
But I'm sorry, my lord, item 13 was passed over on my ground. After this group. Well, 18 I appear.
What is this application?
13 I 18. My lord, the petitioner other side here. What's the next one? That was 2018. Oh, nothing greater.
What is the application?
Yes, madam.
It's for the other side. Have you served?
Yes, several service is there. स्कूल को दीजिए तो देखो तुम भूल नहीं होता को सर्विस तो
Yes, with the additional government, Peter. Why don't you appear in the matter? Nobody is responding.
তুমি আছো নাকি এটা কে আছে দেখে খবর দাও তো 1810 ক্যান নাম্বার 1 না দেখি কি বলছে
Yes. Why don't you appear?
Your lordship,
Despite service, there is no appearance on behalf of the respondent.
pension
You have not challenged the order? So
yes
take instruction.
well let it be on 5th your lordship kindly
No. Next
no
2
after your lordship
2 weeks.
adjourn the 2 weeks again adjournment that will be
Item number 19.
Item number 90, I am for the applicant.
Yes.
I am for the applicant.
I am for the respondent.
My lord, here in this instant case, my lord, both the appellant and the writ petition before the learned single judge prayed for a similar order as decided by the division bench, but without following the division bench, learned single judge passed that on. My lord, his submission is recorded. I can My lord, kindly come to page 54. The order impugned.
No, internal page.
Internal page, my lord. My lord, 56.
Internal page. Of the
Internal
impugned
page
order.
3.
Read.
My lord, last paragraph, may I please? My lord, please turn
Just
over serial number 3,
Just wait.
division bench. But we are also agreed with that since the division bench has settled that issue on page 62. And we are the district primary school council. We are agreed, but all parties are act with the order of the division bench, page 62.
So the government has created a supernumerary
But
post.
in the case of the petitioner has not been created supernumerary till date, as because, my lord, we are sending the proposal to the government for creating supernumerary.
The state.
Lordship, I am for the state. But Lordship, as for the Lordship earlier order division bench Lordship, some Lordship I have not prefer an appeal, that Lordship binding, but here Lordship give me some observation regarding the super post Lordship.
No. The council has agreed, but you have to create a supernumerary. To take a decision and come back.
And as because, my lord,
Our attention is drawn
Lordship, only one
to the,
submission
to
from.
the orders passed by the coordinate bench
21.
আমার নোটিশ দিয়ে আসবো বলেছিলাম না But I'm for the Oh, well, affidavit of service is there. On the last occasion, since nobody appeared, your lordship for the state, your lordship directed me to give another notice. That has also been given.
No, there's nothing. There's no order recorded.
Oh, that's one probably your losses without any record. Further notice was given. If your losses,
The prayer made in Calcutta.
instant application, I tell your losses can dispose.
Just 1 minute.
Just kindly see the impugned order, page 41. যে দুটো কপি আছে পাবে এটা তো
Let them file opposition.
No, I think your losses may dispose it off. May I take your
You
losses?
will dismiss your stay application. We are taking.
No,
up-
we are not taking stay application.
Then the appeal has to be heard, then we'll hear out.
If your losses kindly at least look at
I have seen that.
the two documents.
I have seen that. I have seen. Interim order will not grant because there has been a considerable delay from 2019 to 20.
No, that's I'm trying to make out. Your losses
24.
kindly at least
So,
1 minute.
You withdrew it. We accept that you withdrew it with liberty to file afresh. But there was a considerable delay.
No, may I make one submissions? Just your losses. I'm not. Your losses nine.
For interim order. We are not going.
No, I'm not even asking interim order. Your losses, kindly look at.
So we are saying that the application is surpluses, disposed of, and main matter to be
No,
discussed.
kindly, we said the died in harness case, your losses kindly do not do that. You'll kindly look at least. Kindly look
We are
at
not
this.
going to decide any appeal.
No, I'm not asking for decision also, reconsideration. Why I'm saying your losses, kindly look page 37. Kindly look at it. This is the impugned order in the writ petition. Admittedly.
I can't read it.
I take your losses to both. I have Malan, both. Joseph.
The married daughter.
Married daughter. Now, this is settled law. A married daughter is also entitled to be considered.
When you died, when your father died,
7. Now, your losses, kindly see the very next page. Your losses, I have given your losses a bunch. Your losses will have both the orders. Your losses will find 22 April also in these 3-4 papers. So he realized his mistake. He again directed the petitioner to appear with all documents. Petitioner appeared, submitted the documents. Now this is still pending. So this was not brought to this. This is your losses reconsideration only. Absolutely full from our side. I admit your loss from this side.
But these documents have.
I have annexed your losses to this.
They have an opportunity to deal with that document. Let them come.
That's your loss. Well, I can give another notice to, I don't know why they're not coming. This is the thing, your losses. I'm not asking for any mandatory order.
There is no representation on behalf of the respondent after hearing the after
They say we got approval from AICT. That is when the university wrote to AICT saying, please kindly comes to the university's letter to AIC, page 65. It may be kindly recalled that NOC of the affiliating university is mandatory in respect of starting new course as per AICT approval process handbook. The university is required to issue NOC as per format 2 prescribed by AICT.
Handbook, I just wanted to know whether it is the executive instruction.
Lordship, I had shown your Lordship, kindly takes this up. I have spoken to your Lordship on the last, the Gazette notification. No.
Yes, yes, it must be
Lordship,
here.
that has been handed over
Yes,
to your Lordship.
yes.
Gazette notification.
Yes.
Lordship kindly comes to clause 4.11 of the Gazette notification.
This is of AICT.
Yes, All India Council, they have a regulation, regulation 2016. That regulation provides that the council.
Annexure 2 is their AICT regulation.
Lordship, AICT, All India Council for Technical Education. Lordship, may I read the first paragraph? In exercise of powers conferred under subsection 1 of section 23.
No, I am asking something different.
Lordship.
You are referring this particular annexure where this provision relating to annexure is concerned. Is it a part of the regulation of AICTE or?
It is a part of the regulation of AICT. That's what I'm trying to
say. Not the university's document.
No. This is AICT's document. AICT's document.
Yes.
Lordship, at 4.11, it provides that the council.
No, I have read it faster than you.
I'm sorry.
Says that the AICT is within its power to issue a handbook regulating this. The only thing is whether it is a part of the handbook or it is not a part of the handbook.
Lordship, under these regulations.
Please, page 57 is a part of the handbook or not a part of the handbook? Which you rely on.
Lordship, at the very beginning, it says it's a legal document. AICT handbook says this is a legal document. Lordship, I'm sorry, I could not.
Madam, in a truncated manner, one page you have annexed. We do not know from where you got this page. We are asking you a very simple question. I think my English is very bad.
No, I'm sorry, I did
Whether
not.
This truncated document, one-page document, is of the handbook,
Yes, it
from
is.
the handbook or
Yes.
not from the handbook?
Yes, it is.
If it is handbook issued by AICT.
Yes, Your Lordship.
That is what I want.
I'm so sorry, I did not.
So that I can apply 4.11.
Lordship, I'm extremely sorry. Yes, it is part of the handbook.
This is
And
what I really wanted
I
to
did
know.
not understand. I'm sorry. I did not understand. So therefore, I was saying that this was.
Who is for AICT?
Lordship, Mr. Debu Chaudhary, I have given him notice. He said he'll appear online, but I don't see him.
If he does not appear, then what can be done? Yes,
Lordship,
you are the candidate.
Lordship, I will just one more point. One more
Even
point.
the bench is convinced. One more.
I'm sorry.
No.
I will not. I will not. I am not.
Yes. How can it be done? If it is
I-
a
I-
handbook which has a statutory flavor, how can you?
I tell you, Lordship.
Pass it?
I tell you.
You are a college.
I'm the college. I have been
How
approved.
can you do it?
This is not, I have done it.
Yes.
This is not, I have
The
done it.
wrong. The wrong.
I tell you, Lordship, there is no wrong. There is no, just. No, my lord, here, your Lordships, the approval is given by AICT.
Correct. But the handbook says that no objection has to be there. Now, if it is not, then the AICT has committed wrong.
No, I tell you,
It's his own mandate.
No, I tell you, Lordships, This is a report of the scrutiny committee. I give you, Lordships, how this is processed. This was placed before the expert evaluation committee. Expert evaluations committee considered it. Then it is placed before the executive committee, all in the portal of the AICT, apex body. Executive committee granted the approval. Now, this is the requirement of the AICT at best. This is not the requirement of my learned friends affiliating body. They will simply act on the basis of the approval, subject to their provisions of the regulations and the act. Now, I tell your Lordships, they are
when the process started, they gave a notification, the affiliating university, that give intimation. And the last, if you start any new course, this is a 20 years old institution, they have other courses. Give intimation to the university if you going to start any new, apply for new courses to the AICT. That was the last date of 16th February. We gave them the intimation on 15th on record. That's admitted by them. After giving them intimation, we applied. Application was processed according to their regulations and bylaws. Then this entire thing was governed. And this no objection is not at all mandatory.
Where do I get it?
I take your losses.
What I really wanted
I
an answer
take your
from.
losses to that. Process to that. Now this is the complete handbook of them. I give your losses 2 copies. Oh, sir. আরেকটা কপি আমার আছে না একটু দিন দুটো এটা আমার তো Now I take your losses page 17 of this handbook, if your losses kindly come.
Yes.
Clause, I tell your losses, clause
2.7.
I just your losses. I probably in my notes, I'm sorry, page 7 first.
Yes.
Now your losses will find how this is to be proceeded. Kindly see, A, B, C, D, your losses will find everything is online. E, application shall submit online a set of attested copies of original documents to the Regulation Bureau, produced during online scrutiny and re-scrutiny committee. The scrutiny committee shall verify the authenticity of the documents submitted by the applicant, as mentioned above, and shall countersign all the documents that are accepted. My first point is that I submitted all the documents. If it is a required document, system will not accept my application. If it is a required document by them, system itself will not accept the document. Admittedly, I didn't have no objection. Then your lordship, clause 2.7 at page 17. Well, kindly have a look at this, to start new program. This is new program apart from the 13 programs we are running since last 20 years. This is a new program, AIML. The point A, I will just place point A to E. The existing institutions seeking approvals to start a new program or level shall apply on AICTE web portal along with the extension of approval from the existing programs and courses with the additional documents as per Annexure 2 to the approval process handbook. The institutions applying under the break-in AO restoration are also eligible to apply. Now I take your losses to point E. To start new courses under new program shall be processed as per clause 2.6 of the APH. This approval process. Then your losses kindly come to page 77. Kindly see. Documents, the heading is documents to be uploaded or submitted or shown at the time of scrutiny of the re-scrutiny. Your losses kindly consider the entire thing, your losses. I will take further. Your losses will not find that. I will straightway take your lordship to Annexure 2. This is your lordship, that clause my learned friend is showing your lordship's annexure. No objection certificate form. that's to be submitted. Your losses will document at the time of scrutiny. Now, the scrutiny committee, your losses will find, I have annexed the report also. They say this document is not required. Column, this is an affidavit clause. But first, I could not have submitted my application. Yeah, unless this is a required document. Secondly, this is say that. Then your lordships will find, kindly come to page 186. Well, this is your lordship for the application of the entire new course. Your lordships will not find any documents mentioned over here. No objection. This is the application except closure of the institution. I am not closing my institution. So, they proceeded on that basis and gave me the approval. This is not their requirement, always. Had it been a requirement, I could not have submitted the application. And they proceeded, and your lordships, all the documents are not annexed to the MI stay, their stay application. I can take your lordships to the, I have prepared 2 copies of the writ petition for your lordships. Kindly have a look at this. I will take your lordships, how this has been proceeded with by the authorities. But I will take, my lord, 2-3 pages of this writ petition.
This is writ petition.
But this is the this order is because entire writ petition are not before your lordships. Malad, kindly have a look. Only the relevant portion I will show. Malad, page 75. This is the report of the scrutiny committee. I will take your lordships to the handbook, how this is processed. Scrutiny committee is first placed, then evaluation committee, and then both the report goes to the executive committee of the apex body. I will take your lordships just now to that. Let me place these documents, your lordships, how they are proceeded with. The institution is that not fault. Page 75, your lordships will get it. Scrutiny evaluation report, your lordships. Get it, your lordships. I show your lordships. Only your lordships, the relevant portion of it. Page 76, your lordships. Last but one column. Artificial intelligence and machine learning. This is the new course or program we were asking for. Now, kindly see the next page. Column 3, document verification. NOC from affiliating university or board, not applicable. The document is not required. This was what the scrutiny committee says.
What?
Your lordships, kindly see. Document verification, page 77.
Oh, NOC.
NOC.
First column.
Column. Second column, third point, your lordships. NOC from affiliating university or board, not applicable. The document is not required. These document, then your lordships, after the scrutiny, this was placed before the executive evaluation committee. Your lordships, kindly come to page 84. This was all on portal. We have got it everything from portal.
Yes.
Then your lordships, kindly see report of the expert visiting committee. This is as per the handbook. This was placed, your lordships. Kindly see page 87. From the top, third column, your lordship, this is computerized system is like this, I find. The third column, 2024, just behind that left-hand side, artificial intelligence program, your lordships, they have written like this. ARTIFICL, artificial intelligence and machine learning. Then your lordships will find intake 60. So this is the report of the evaluation committee. And then your lordships, kindly come to page 135. Approval. Kindly see, this was the approval given. Now, kindly see the middle portion of it. in terms of the provisions under the All India Council for Technical Education such and such, yes, the such and such, to regulate the technical and subsequent regulation of ICT, I am directed to convey the approval to, just at the bottom, the first one, undergraduate engineering and technology, then subject course mentioned, artificial intelligence and machine learning. And then your losses, 60th, the intake capacity. Now, if your losses, just take for how this is being, and then before that, your losses kindly consider page 146. আচ্ছা ওই পেজটা কোথায় যেটা actually intimation দিতে বলেছিল আমাদের সেই প্যারাগ্রাফ 146. This is before application. Their notification was that please intimate us if you want to start any new course. The university's notification. That's why we give in the intimation only. Velocity kindly came to page 146. দেখিয়েছিল আমাকে এটা intimation clause-টা দেখো. This is 15 February, last date was 16. There is a document I will show to your losses.
Yes, that you have said that, yes, we have applied for new courses.
New courses. So this is the intimation they only sought for. They never sought for that I have to take no objection certificate.
Where is the communication that you simply intimate?
Only intimation. What is that? And there is a communication. Just I'm showing that your losses. Their own communication shows that your losses. Intimation has to be given. Just a minute. Last date chilo 16 that was given to us. Just I will show that just how the process was done. Let me place in the meantime, I will take your losses. Kindly your losses take up the handbook once again. I've read it also that your losses. Vishal Mota. That there is a procedure that how to be pasted before the committee. আমাদের অ্যানেক্সটারই আছে দেখুন
P4 140 intimation.
P4 of
এই যে repetition
140 just a minute Page 140 of the writ petition. আচ্ছা অ্যাপ্রুভাল প্রসেস যে ক্লজটা দেখালাম না প্রথমে এক্সিকিউট তারপরে তিনটেতে যাবে সেই ক্লজটা বার করতে আমার নোটস আছে কিন্তু মিসিং দেখতে 140 140 sorry of the writ petition. This is updated 4th January 2024. This is hereby notified for information of all concerned. The AICTE provides its public notice for approval process of 2024-25. Dated NIL of the member secretary AICT has invited application for approval from all technical institutions for conducting technical programs or courses, including course for management for the academic year 24-25. It has also been notified in the said public notice of AICTE that submission of online application for the sessions 2014-2015 in respect of all approvals that shall begin on 27th December 2023 and end on 31st January 2024. The last date for submission of online application with penalty for extension of approval based on self-disclosure of the existing institute is permitted up to 7th February 2024. Management of the college desiring affiliation from the university is hereby informed that this university will not grant affiliation to an institution approved by AICT beyond the date as will be stipulated in the academic year of the AICT to be published in the official website of AICT. Then, your lordships, the management of the existing college applying for any type of new approval of AICT as stated in the AICT public notice stated below for such and such is hereby requested to intimate the office of the undersigned within 16th February 2024. We intimated that. Then we filed our application. And that was proceeded with. Your losses will find the very next clause, table 1, serial number 1, to start new program. This is a new program. The other programs were there. And I tell you, losses, in the other 2 programs also, there are 3 new programs, BB and that. They have already given affiliation. There was also no objection certificate. So, their act is not consistent. And AICT, the apex body, they grants this. Obviously, they have their elaborate procedure was there. They have made inspection, even online inspection is being done virtually by the AICT and then granted. It's a self-finance institution. Of course, your losses some, but it's not that a philanthropic society. Or a normal.
Even then.
Even
then, when you are conducting a course and
that's
granting a certificate which is recognized all over the world, then at least you must have an affiliation.
Otherwise, that's why we have come up with your lawsuits. That after approval, how can you withhold the affiliation? Then we moved this honorable court at the last, because we didn't have anything to approach to anybody. Then we approached the court, honorable court, and this was done. So this is the entire thing, your lawsuits. And kindly have a look at the your lawsuits. The so far the impugned order, kindly the AICT submissions that has been recorded. Lawsuits, kindly consider that. That must be brought to your lawsuits notice. Page, I take your lawsuits to that order.
Page 54, your lordship.
Paragraph 8. The learned advocate representing AICT has submitted that the council intends to clarify their standby of an affidavit. As the council has granted approval to the technical course, accordingly, the council does not stand in the way if the institute proceeds with the process of admission to technical course. This was the submission of the AICT. So we cannot be taken in between. We complied with all the formalities. This is one humble submission. This is an interim order before lawsuits. And on the last occasion, the learned single judge observed that there is no stay. You can't play with the students. You file your affidavit. Even then, they have not filed.
Lordship, I have filed my affidavit.
I-
My learned friend is not correct. I have filed my affidavit. But Lordship,
Yesterday afternoon, they have served.
This is against the
interim order.
interim order.
Lordship. Lordship, the only thing that I was pointing out, my learned friend said about BBA and BCA courses, we did not insist upon a NOC. Lordship, that is because for the first time, it was previously a non-AICT course. It has now been brought under the umbrella of the AICT. Therefore, it was quite made clear that no objection would not be required in their case. But in this case, Your Lordship, whatever my learned friend has been submitting,
Whatever your documents are there, you do not
Lordship,
say
those
you did not say BBA or something of that kind. Everything you have said is
Lordship, the intimation may have come. I'm not saying, I'm not standing in the way. The intimation may come, but Lordship, it is as per the formalities.
let the single bench decide.
Lordship, kindly, one thing, Lordship, this particular college, Lordship, this particular college is in its doldrums. Lordship, this was what I wanted to point out to your Lordships at annexure P8, page 60.
Why don't
The faculty, Lordship, have not been paid for 26 months. The students themselves came to us asking for transfer from the college. Why we say this particular college kindly comes to page 66.
that can't be a criteria here.
Lordship, we would have, the no objection was very, very important for that reason, Lordship. We would have evaluated the condition of the.
Why did not intimate to them?
Lordship, we have intimated. We have asked.
Why you have not withdrawn the affiliation as a whole?
Lordship, so many students, so many courses running together. We
have said that we will not.
Lordship, Lordship, there is a rule that where there is a AICT course in a particular college, we cannot take away the students without first AICT giving permission. Your Lordship, may I?
My lord,
that
if I am permitted, my lord, I am appearing on behalf of the council, my lord, AICT, my lord.
What do you want to say?
No, my lord, we reiterate our stand that, my lord, there has been a scrutiny whereby, my lord,
that is what it says.
We stand by our submissions on the last occasion, my lord, that we made in the WPA, my lord. The extension has been granted after an amendment, and this course has been included through a corrigendum, my lord. So now it is up to the university, because as far as AICT is concerned, they do not need an NOC from us, my lord.
Lordship, it is their stand that they do not require an NOC. Then why have they insisted, and why has this particular college, I'm asking myself, why has this college written to us saying that we could not apply for NOC? If it was not required.
No, it was not. The only thing is that intimation, we have given an intimation.
Lordship, not just an intimation, Lordship, I have shown from my documents.
On 15th of February, they gave you
Lordship,
wanted them.
They have given an intimation.
That's all.
But I have said in my Lordship, the portion that I.
We are not concerned with this. can't do anything.
Disposal.
Think of the plight of the students.
Lordship, only thing I
My
was
first paragraph is the reflection of what is happening there.
Lordship, there was
Don't
no
be
ego
egoistic
fight. There was
in
no
this
ego
regard,
fight. This
that
was
you can't
Lordship, this was
be
not an
there,
ego fight.
flag an issue with them, so that henceforth they will not, but not in this fashion. Anyway.
Speaking from my lord's my lord, to file the cross objection or without the certified copy on the server copy, my lord.
Not required. Certified copy is never required in cross objection.
Very good, I shall file it. I understand what.
File it. It's not required.
Yes.
Yes. Yes.
This one. Lord, this is my cross objection, my lord. So we have filed the cross objection after taking the leave from the competent court, my lord. Even number 3 cross objection file করলাম
আমরা ফাইল করলে আমরা তো ফিল লিখতেই নিলাম
আমরা লিভ দিন ইচুয়ালি ফাইল করে দিয়েছি দিয়েছি কবে সব প্রবলেম
Suit for recovery of position dismiss.
Yes, my lord.
On the ground?
Ground where no cause of action, my lord.
No cause of action?
Yes, that is the, well, after trial it has been found, my lord, there is no cause of action. My lord,
Or is
ground to, my lord,
barred
have
by
taken.
law?
Ground to have taken, my lord.
The ground of jurisdiction?
Not ground of jurisdiction, my lord. Kindly take page 55, my lord.
My lords,
First is cause of action is barred by order 9, rule 9.
No, order 9, rule 9 is a restoration.
That
Which
is
was
barred. They have
dismissed
filed a
for
suit, my
default.
lord. They are dismissed for default. They cannot file another fresh suit, my lord. And the cause of action, yes.
It's not a cause of
Yes,
action.
that is
It
there
is
also, what I'm
really a
saying.
bar.
That is
That's
bar.
the word is used misnomer. There is a misnomer in that.
Right, my lord. Then, my lord,
It
kindly
is
take page
really
55, my
barred.
lord.
Fresh shoot
Yes.
does not lie.
Right, my lord. That is one of the ground, my lord. Another ground is cause of action. Page 55, my lord. Kindly come just before.
No, here the learned judge has used the word cause of action, but it is wrong because there is a bar of suit under order 9, rule 9.
That is there. Cause of action was not there. 54, my lord. Kindly come. Just before the fetch.
Which for the other side?
Lordships, what the plaintiff has preferred an appeal, and defendant number 1, I am appearing for the defendant number 1.
What part of the finding is against you?
Lordship, Lordship, the fact is the occupant has been paying the rent to me for several years.
Occupant?
I am the state. So I have been receiving the rent. I have been aggrieved, and defendant number 3 has been has aggrieved as well as the plaintiffs.
The suit for eviction was filed or recovery of possession was filed against whom?
Against the state as
of
well
West
as
Bengal.
yes, as well as the person claiming to be.
State was a lessee.
Yes, Lordship.
State was a lessee.
Yes, Lordship.
When both of you can argue the matter?
Lordship,
On a proposition of law.
Lordship, I have.
Tell me.
Lordship, my
And why you are aggrieved? You wanted to file cross objection.
Lordship, I understand. I have preferred a cross appeal. Lordship, may I come back with my cross
Tell
appeal?
me when.
Lordship, I am not prepared today. Lordship, may I come back with my
I know that you are not prepared.
Yes,
Tell
Lordship.
me when you can prepare yourself. Tell me.
Lordship, any day. I'm led by Mrs. Banerjee. Lordship will
I
allow
do not know. Please tell me.
a week.
So
Lordship,
that Mr.
Lordship
Banerjee
will allow
will not come and ask for a.
Very well, Lordship. May it be
accommodation.
taken up
Which Banerjee?
next week, Lordship.
Which Banerjee?
Noel Banerjee, Lordship.
Yes. So tell
Lordship,
me.
may it be taken up next week, any day, your Lordship.
Tell me the date.
Which matter? The next one, not this one. This one. This is cross objection.
Tell me the.
Our cross objection.
Lord, I am for the
Lordship, on 21st of January.
January.
21st.
Order 9, rule 9 bar. Cause of action change.
That's it.
cross appellate increase issue হবে এটা
correct না ঠিক আছে এটা তুমি করে দিচ্ছ
point of view
এটা মার্ক করা আছে দাঁড়া
Lordship, 21st of this month, Lordship.
Yes.
Serial number 1 is the appeal filed by the defendant number 3.
That's us.
I shall indicate my number. The leave has
Who
been
is the
granted.
defendant number 3?
Lordship,
Should we appearing?
What is his status? What is
Lordship.
your status? In the
Will be the Tika tenant, my lord. We are the Tika tenant, my lord.
Who is the plaintiff?
And I appear for the appellant.
The plaintiff.
Plaintiff.
My
The
lord.
plaintiff.
And in this application has not been served to me. This item
Cross
number 1.
objection.
cross.
Notice will be issued, my lord.
You gave.
As Lordship, I have also not been served. I am also.
As
You
it
have
is
filed a
notice.
cross objection.
Yes, I have also.
So where
filed.
is the copy of the cross
Lordship,
objection?
the leave has been granted. Lordship, we are filing it today, Lordship.
So what is appearing today?
Lordship, the
It's our cross objection which is appearing.
Your cross objection.
Our cross objection.
Wonderful.
And item number 18, my lord. That is our
Item number 18 is the appeal, my lord, which has been filed by the plaintiff.
Oh,
I'm sorry, my lord.
I understand.
I'm sorry.
I understand. So can you prepare an informal paper book by 20th?
Like 20th.
20.
In the item number 18, paper books have been prepared.
Already prepared?
Already
Yes,
Then
Lordship.
it's
Directive has been
no
given.
difficulty.
Yes, ma'am.
So we can fix this matter on
Any page can we-
21st.
21st.
Paper book is already there.
My lord, that has been
Go
prepared.
file your cross objection. Give a copy of the cross objection to him.
Lordship.
I shall file the paper book in the court right now.
We'll also
Say
serve
that
on the
paper book has already been
How
filed.
to issue?
File department is a court file.
Court file. I'll be filing here. It has
Where
been
is
prepared.
that? File it. Copy has been served.
My lord, memo has been sent to them.
Come.
Memos have been sent
Give
to
the
them. my lord.
copies.
That is,
Please, please.
I am just
Give it to them now.
copies are there. I shall serve the copy in the course of the day. In the course of the day, I shall serve the copies.
Don't you understand that what is passing through the bench?
Lord, I am understanding. I shall serve within.
You are a plaintiff and you do not understand what is passing through the bench. Serve in course of. Give it a copy.
I shall. Just give it. Within course of the
Give it.
this copy and the court copies. I shall. This is the court copies. I shall serve the copies in due course of the day.
How many copies you have to?
From volume 7. And
Lordship,
two
these are
sets,
to be filed.
two sets are there for the court. A total 7 volumes. I should serve it.
Contain a thinner one, only one volume.
No, that is not possible.
Purely on a question, proposition of law. Purely on a proposition.
On points of law, my lord.
This is the cross objection at the behest of the defendant number 3 in the suit.
Lord, this is specially assigned. I appear for the appellant. Lord, the date may be fixed.
But I appear for the writ petitioner respondent.
But I appear for the private respondent.
You appear for?
The writ petitioner respondent.
You are for private
Private respondent who has been selected by the High Court administration. My appointment letter was also issued, but I could not join due to interim order. I am suffering the interim.
Main matter is pending.
Yes, yes. Against the interim order, my lord, this appeal has been preferred.
Is the interim order which is passed?
I just indicate. Let 104.
From the
Stay application.
yeah, no, from the tuned order, internal page.
Just
106 internal
page 3.
Note 3.
This is entitled to give appointments to all selected candidates, except filling up the vacancy under OBC BEC. This is what the interim order.
Yes. But I was selected for that post.
The OBC BE.
Yes, OBC B.
So you are not challenging that order.
I have not challenged because writ petition is pending. But the
Lord, the writ petitioner applied as a general category candidate.
Writ petitioner applied and he has been selected where?
He has not selected. He never comes within the zone of consideration. Although he is a scheduled caste candidate, OBC candidate, he applied in the general category.
No, it says that the pendency, the respondent will be entitled to give appointment to all selected candidates, except filling up the vacancy under OBC BEC category.
Yes, therefore that is stuck up.
You are concerned with this, that why not
Yes,
this also?
yes, we are suffering. Subject to the result. Subject
But
of
I'm
the
ready.
result.
I'm ready.
Subject of the
When both of you are ready for the final hearing,
Lord, any day, Lord.
tell us.
Not accepting next week.
Tell us the date.
Lord, may I suggest, Lord, can we
28.
come back on the 6th of because I'm led by Mr. Joydeep Kaur.
No, when? Tell us straight away.
6th of February, my lord, subject to my lord's sanction. 6th of February is a Thursday. Original side matters are taken up on the Tuesdays and Thursdays. Right?
This relates to which post?
Assistant Registrar, Court Recording, original site.
Was I a party of the committee?
No.
No.
Sure.
Because 28
This pertains to which selection process? Which year?
2021, but it culminated in 2024.
My brother was holding the Registrar General, whether he has any role to play.
No.
That the High Court administration can answer.
My brother was a Registrar General at that point of time.
No, this recruitment notification, my lord, was floated by the learned registrar, original site. Honorable Justice Biswas was the Registrar General.
Yeah, that is what I. He has nothing.
No
role to play.
No.
Tell me which.
6th of February, my lord.
6th of February. The matter has come up by way of an assignment before us.
I'm led by Mr. Sukrit Mukherjee, my lord, who's appearing virtually, my lord.
I'm for the respondent.
My lord, items number 3 to 8, I appear for the appellants, my lord. I'm being led by Mr. Sukrit Mukherjee, my lord, who is appearing virtually.
My lord, I appear for the appellants, my lord, in these matters. My lord, 3 to 8. My lord, am I audible to your lordships?
Yes, audible, visible, both.
My lord, 3 to 8 have all been assigned to your lordships.
Yes.
My lord, they were before Justice Shen's bench. His lordship was, my lord, was in the trial court when one of the orders was passed, my lord, which was challenged by us in this application.
So tell us when we can fix the matter. So
Your lordship,
motions.
subject to your lordship's convenience, any day next week.
The amendment has been, my lord, after the order has been passed, my lord, suit has been amended. And my lord, that.
What are you taking? What are you saying? The CS is also dismissed. Suits have been dismissed.
No. It's been amended.
One of the plaintiffs had died. They have effected substitution of that.
One of the Shebayat of the my lord, plaintiff has been died and his heirs has been substituted.
No, you are assailing which order?
My lord, it is my appeal. My lord, I am assailing an order, my lord, by which
10th of February.
My lord, 10th of April 2024.
Sorry, 10th of April.
Yes, my lord.
Come at the last portion of the order.
Yes, my lord.
Paragraph 21.
Yes, my lord. Paragraph 21.
It says GS7. Oh, in CS.
In CS, yes. The GA applications have all been dismissed, which were my applications. 6 separate suits, my lord, 6 separate interlocutory applications were taken out for dismissal. Those have been rejected.
When we can fix?
My lord, any day next week, my lord, subject to your lordship's convenience.
Carry out the amendment, my lord.
What carry out the amendment?
Because, my lord, the Shebayat has been died. My lord, now it's in the name of the Shebayat, so that's required to be.
What carry out the amendment? Amendments have been refused.
No, my lord. This is my suit, my lord.
My lord, what my learned friend is possibly saying is, after this appeal was filed, my lord, in the suit, they took out an application for amendment to, my lord, record the death of one of the Shebayites of the plaintiff deity estate, and my lord, that has been allowed. My lord, the advocate
will have to affect the change.
Yes, my lord, I'll carry it out, my lord.
So you'll have to affect the change.
Yes.
The matter has come up by way of an assignment from the office of the Honorable Chief Justice. It is submitted.
See to it.
I mean, let them Mr. Mukherjee, my lord.
But I'm for the respondent.
Why it has come for assign after this?
Well, Justice Sen had released the matter.
For the first time, it's come up.
Justice Sen's bench, it was originally before Justice Sen's bench. My lord, one of the counsels appearing in the matter was his One of the counsels appearing in the
It's
matter
our
was
appeal, my lord, after assignments come up for the first
One
time.
of the counsel?
appearing in the matter for the appellant, my lord, his family member,
Lord,
his Sen's family.
Junior Mr. Sen, my lord, is
Sen.
here.
So, my lord,
So, my lord, it's
he
been
had to
released.
release the matter.
But the appeals have to be, my lord, heard.
Who is
The issue?
This second degree of junior or first degree of junior?
Second degree.
The last degree of junior, junior most.
Second senior most is still there.
I'm now, my lord, confused. I'm so sorry, my lord.
No, I'm actually.
Huh?
No. My lord, before the earlier bench, my lord, Mr. Sen, my lord, is with us, my lord, in the matter.
For the appellant.
He says junior Sen. That's why I say the second degree junior or
Immediate.
Immediate.
but I think the senior Sen is still there.
Yes, father.
হ্যাঁ কিন্তু উকিল ছড়াই
No. It's not matter.
He was a lawyer.
He was a lawyer, but
Yes.
never, I don't think has
I don't
practiced.
think, my lord.
Has practiced.
After all,
Oh, that, my lord, I don't know. I'm-
regarded as a senior Sen.
Yes.
Oh,
He's still there.
Lord,
I didn't know that. Andrew Kashmir.
Yes, on the lighter side.
I'm sorry, my lord. I didn't know of that fact. Otherwise, my lord, I could have, my lord.
What is this?
My lord, this is really, my lord, under the Copyright Act. My lord, Vodafone, my lord, has, my lord, the ringtones. My lord, we entered into an agreement with Saregama, my lord, who is, my lord, the owner of the my lord, sound recording. Now, my lord, there were certain amendments introduced, my lord, to the Copyright Act, my lord, in 2012. Question arises now.
19 or what?
Yes, sections 18 and 19, my lord, your lordship's, my lord, aware of that. So, my lord, the question has arisen now, my lord, as to, my lord, even if I have, my lord, an assignment or a license, my lord, from, my lord, the owner of the sound recordings, am I required, my lord, to pay royalty over and above that, my lord, to, my lord, the, my lord, persons, my lord, who claim to be, my lord, owners of, my lord, the musical work and, my lord, the literary work. That's, my lord, the music composition as well as, my lord, the lyrics. My lord, which is now, my lord, the Indian Performing Rights Society, my lord, who, my lord, is, my lord, the registered copyright society seeking to represent, my lord, the owners of, my lord, these, my lord, works. So, my lord, this is the issue. My lord, we lost, my lord, before, my lord, the learned single judge. My lord, we have now, my lord, come up on appeal. In any event, my lord, no bench of, my lord, Justice Sen could have taken this up because Justice Sen, my lord, had, my lord, in that same matter, passed, my lord, interim order sitting as a learned single judge.
Ask us to deposit that.
So, my lord, now, my lord, we are, my lord, before your lordships. My lord, it was taken up by an earlier division bench. There are interim orders, my lord, which have been passed, my lord, which are, my lord, subsisting as of now. My lord, we have to, my lord, make deposits, my lord, in court, and, my lord, affirm affidavits, my lord, giving the, my lord, position.
So when you want it, because
My lord, anytime. My lord, I'm here by and large, my lord, these days. My lord, I am, my lord, I have opted out, my lord, from the race now, my lord. I'm planning to, my lord, put my feet up pretty soon. I'm here.
But my instruction is.
I'll have to see that, my lord.
But I am being led by my lord, Mr. Anindo Mitro. My lord, I would be. My instruction is, my lord, that if this is skipped, my lord, after the first week of February, my lord, then, my lord, it would be easier for us because, my lord, I have to, my lord, hold conferences with 3 seniors in this matter. Mr. Anindo Mitro, after Mr. Abhijit Mitra and Shomur Rajput, my lord, I, my lord, also take, my lord, time to sit with all of them depending on their availability. So, my lord, kindly, and there are 3 appeals, my lord. So kindly, my lord, keep it, my lord, at any time in the first week of after the Saraswati Puja.
Second week.
New application.
No, my lord.
No, my lord, these are all.
Orders have been passed in the
My lord, orders have been passed in the new application. The appeal really needs to be heard, my lord. My lord,
any paper book in the meantime is.
my lord, we can file a paper.
Informal paper book.
My lord, my lord, could we file, my lord, an informal paper book, my lord? Lordships kindly give direction so that everything is at one place. And my lord,
though the matter is listed today after the assignment
Made, please, Your Lordship. Lordship, this is an assigned matter, has been assigned before Your Lordship.
So, Miller, what is the matter?
Lordship, this is an appeal under an application, rejection of an application under section 47 of the
47.
Code of Civil
You
Lordship,
filed an application under section 47.
Lordship, I did. Lordship,
Are you ready?
Lordship, today, Lordship, I am ready.
Today itself?
Lordship, I am ready.
Any, yes, my
Only,
lord.
only one thing which I have to bring to your Lordship's notice is that on the 8th of January, Your Lordship, certain modifications have been made in the original order. Very minor technical modifications. May I hand over?
Not modification, my lord.
Certain corrections, typographical errors.
Typographical errors.
So, Your Lordship, that has to be brought before Your Lordship. I'll bring it up some other time.
That's why I asked if you are ready. Argue. If you want time, tell me when you are ready.
My lord, may I indicate just one thing, my lord? Before the appeal has been filed, one of the respondent has died. And they have, my lord, knowledge of the same, my lord. Before they filed the appeal, the respondent has died.
When died?
My lord,
before the order or after the order?
after
Before the appeal?
the order was passed, but before the appeal was filed.
The order 22 takes
Yes.
care of that. Not
Yes,
this one.
yes.
Bring the name.
I'll bring them on record, Your Lordship.
The matter has come up by way of an assignment from the office of the Honorable Chief Justice. It is pointed out that one of the same order.
12 and 13.
I'm grateful.
I'm grateful, Your Lordship.
No, 14. 14, my lord, I appear for the
Appear for the appellant.
my lord, respondent. I appear for the respondent. My lord, I'm being led by Mr. Shubhosaji Chaudhary. My lord, he's not been able to come to court today. My lord, will kindly urgent it just for the week. My lord, just will make it not this week. My lord, being led by Mr. Chaudhary due to personal difficulty.
An accommodation is sought on behalf of the respondent. Let this matter be listed in the next room.
Obliged, my lord.
আলাদা আলাদা করে দাও।
This is that matter regarding the stamp.
What has happened?
Issues are sorted out. Issues are sorted out. The document is going for assessment of stamp duty.
Going for?
Assessment of stamp duty.
It's gone.
No, it has not yet gone. It will go tomorrow.
But
Your lordship will keep the matter after a
after
4 weeks.
Fortnight. Yes.
Let us see.
Yes.
Because the main issue is
The
regarding that
special
step.
officer, the learned special officer comments that the impasse which was created had been removed, and the document would be presented before the registering authority for assessing to assess the stamp duty leviable thereupon. Full stop. Accommodation is sought in this regard. Now, accommodation is sought to complete the entire exercise. In view of the above, let the matter be listed after 3 weeks.
Yes.
Lordship. Any number remuneration we have not given.
Yes,
it
lordship
to.
has not done it, my lord. Your lordship.
I have not done it.
Yes, yes.
I just wanted to give a small.
Yes, yes.
Some token of.
Yes, yes.
Other side you'll have to share, everybody.
Of course.
How many?
Two parties. Two parties.
Two parties,
We are agreed.
1 lakh each. The
Very
initial-
well, madam.
Initial remuneration of the special officer shall be paid by the initial remuneration of rupees 2 lakh. And paid by in equal share.
Grateful.
Within a week from date.
Yes.
Very well.
No matter, এটা আমার মনে আছে।
My lord, this is that application, my lord, for drawing up of the decree, my lord, that was, my lord, filed at my instance, my lord. My lord, if your lordship, my lord, may kindly take it up next week, because my lord wanted to, my lord, had a few queries, and
We can take up this matter in chamber.
my lord.
This is really a chamber application. Drawing up of a decree.
What is, no. So drawing of a decree, now what is being asked for, something which has been already refused in the year 9 twice by this court and the High Court.
Can we have this matter listed in chamber?
Yes,
And let
yes.
us have the entire document, because I find.
Yes, yes. I have no difficulty except 21st any other date.
I have also no difficulty. I am for another defendant.
My lord, any day next week, my lord.
Tell us the date.
21 তারিখ আমি নেই, তাছাড়া অন্য কোনো দিন করো।
22nd.
22nd? 22nd would it be convenient? 22nd?
22nd original side নেই তো।
Original side নেই?
23rd is can be original.
23rd ছুটি।
তাহলে তো আবার next week চলে যাচ্ছে। 28th হতে পারে।
Can it be on the 28th? 28th.
2020th.
28th, 28th. 28th at 2:30.
The department face a difficulty in drawing up the decree passed by this court. The parties have taken out several applications suggesting the form and the mode of drawing the decree. But some of the parties have raised objection in this regard. In order to resolve resolve such issue, let the matter be listed on
28.
Only one. But I am being led by Mr. Law. My instruction is that my senior would be in circuit bench in that week. Can it be on the next Thursday after 28?
I knew it. That's why the bench never suggest any date and leave it to you. You find out and tell
বলো
me.
কবে আসতে পারো বল?
20 তারিখে বেঞ্চ পসিবল। অরিজিনাল সাইড নেন না তো। টিউসডে।
না না 28 তারিখ হচ্ছে তো।
টিউসডে এন্ড থার্সডে দুটো দিন আছে।
বলো তুমি তোমার কবে আসতে পারবে?
21st কবে?
28 তারিখ দিচ্ছে তো।
21st তো বললাম।
বলো।
But 6th of February, if everybody.
6th February, Lordship keeps it. He is agreeing. Mr. Amalesh Rai, my lord, is reading him.
He is in
He will be.
That's why.
কি হলো?
My lord, I am led by Mr. Shoboshachi Chaudhary. My lord, he had requested me to, my lord, take a date next week because, my lord, according to him, my lord, the submission is that, my lord, whatever be it, my lord, is not executable. It is whatever be it.
No, no, I am
When
not on that.
once,
The
my lord, a
honorable
order, a
master,
decree has
learned-
been passed, my lord, the decree has to be
the
drawn up.
learned master said, my lord,
Find out that what is there.
My lord.
yes, there are two immovable properties. They want to
in
include.
case
Without
of
that, my lord,
That
under
is
the
only
CTC.
left. My lord, that is the only thing that is
Yes.
left.
We wanted
My lord, may kindly keep it on 6th, my lord, in case my senior
You
is not,
cannot
but I will
include
try to
anything.
assist
That
your
is the
lordship. Nothing
sixth.
is to be included, my lord.
Yes.
Everything is there.
Yes, only as it is on the face of it. You can't include, my lord, schedule, properties, etc. Because and this has been refused by Supreme Court and the
My
High
lord, when there is a decree, it has to be drawn up.
Yes, draw it up
Grateful, my
as
lord.
it is on the
Grateful,
face
my
of it. That two
Grateful,
pages.
my lord.
Grateful.
to be taken up at 3:30 p.m.
Yes, yes, Lord.
My lord, can it be 3? My lord, most of the days, my lord, we have a
Chambers.
3:30, my lord.
This is in chambers.
My lord. My lord. Grateful, my lord.
Grateful.
My lord, these are all, my lord, connected matters.
But there is one application in one of the appeals.
Disposed of because we have another bench at 3.
But it's a very.
I know, my lord. So, my lord,
Only for change of name. One of the appellants, my lord, name has been changed. My lord, we have annexed, my lord, the certificate of change of name. It's only a consequential amendment in the name of the appellant. My lord.
Will not oppose.
no, my lord.
It is. I have served the corporation. I have served the corporation.
My lord, the private parties, my lord, are the appellants. And my lord, corporation is, my lord, the respondent.
My lord, GA number 2 of 2019.
Kolkata Municipal Corporation extends his territorial jurisdiction over the Chennai.
No, my lord, these are
The name
my
of the
lord,
company.
These are names of companies, my lord.
Tower companies.
Involved in a network, so must be there in Chennai network.
No, my lord,
No.
my lord, these are all, my lord, tax, my lord, on mobile towers. Now, my lord, last occasion when the matter was
The application.
GA2. My lord, GA number 2. Application copy to where is the application copy? Service হয়েছে?
Service করেনি।
না না করেছে করেছে we have
Sorry,
served.
I have not got any instruction from my advocate on record.
সে আলাদা অনেকদিন আগে এসেছিল তো ব্যাটারটা
It's change of name.
কোন matter? আমি তো বললাম
So Chennai has now been converted into China. What is this? I do not know. GTL.
Yes, Lord.
Chennai has gone to GTL. That is the
Yes,
first
Lord.
Gujarat Telecommunications.
It is, my lord, GTL Infrastructure Limited,
means GTL.
Annexure D.
Gujarat Municipal. GTL का.
So from Chennai to Gujarat.
এটা তো order.
Name wise.
My lord, I think there was a merger. My lord, GTL, my lord, was, my lord, a company earlier engaged in similar business. Because there is, my lord, a judgment, my lord, which, my lord, is known as the GTL matter, my lord. Where the Supreme Court.
If your lordship comes to page 56, this is the certificate of fresh certificate of incorporation.
Then what about 2? If it is a merger, then the 2 cannot survive.
2 means
transferring is gone, is no existence.
No, my lord.
Say manager Chennai network.
No, even that has to be.
Chennai network.
No, it has to be manager GTL.
That is what I am saying.
Yes.
Because, my lord,
It is gone. It's non-existent.
Yes, my lord, the employees are absorbed, my lord, usually
yes.
under a scheme. সেটাও
So
change
you
করতে
have not done, you have not done it.
My lord, if your lordship, yes, এইখানটা we just correct it. My lord, kindly see page 57. manager instead of Chennai.
That is what I am asking. Manager of what?
It was filed.
Now, my lord, it was has to be changed.
হ্যাঁ,
Lord.
না ওই তো amended এটা indicate
Should
করেছে
also be deleted.
যখন ফাইল হয়েছে তখন
না সেটা বলছে না এই যে এই চেন্নাই নেটওয়ার্ক এটাকে চেঞ্জ করতে হবে তো। But that I well, kindly give leave to my otherwise everything is correct. But I have in
But the application has been taken out.
your lordship will kindly give leave to that my lord, that correction, my lord. Only in appellant number 2 or writ petitioner number 2, my lord.
Yes, this is an application for amendment of the cost title.
Company was originally করে একটা
ওটা হলো GTL এ মামলা ছিল এই ওখানে একটু
কবে লিস্ট বললো যদি রিটার্নেবল কবে
কি বলছে
বৌদি নিয়ে আসবে না আসবে তো বলে গেল আমার বললো কিন্তু এ তো শুভকে বল শুভকে নাম্বার ওই কর পুরো অসম্পূর্ণ শুভ আমায় বললো চেন্নাই আছে চেন্নাই নিয়ে করতে আমার নেই আচ্ছা ওরা Yes, my lord. Well, I am for the appellant, my lord.
My lord, I'm for the respondent.
On the cause title, there is a mistake, but the mat number and can number, these are correct.
এটা সেন্ট জেভিয়ার্স ইউনিভার্সিটি হবে? Yes, sure. Okay,
Yes, yes.
that's the first title দেখেছো? No, এটা ভুল। Oh, this is the case. না না এটা গেছে। এটাই। Yes, correctionটা করে দাও। This matter is mentioned for correction of a typographical and or ministerial error developed up in the order dated 4/10/2024. According to the counsels appearing for the respective parties, the cost title as depicted in the said order has been erroneously written as এখান থেকে কোট করে দাও within quotes instead of St. Xavier's University
Priyanka Gop.
Yes.
And then thereafter, Mala, she has given a change to Mr. N.P. Gupta.
Where is the change brief? Change Wakalatnama.
Mala, this has been filed, Mala.
It is the Priyanka Gop who has filed the Wakalatama.
Lordships. And thereafter, Mala, it was filed, Mala, by Mr. N.P. Gupta in the court.
Yes, where is that Wakalatama?
Name of review.
In the main matter,
Lordship.
who represented the applicant here?
Mala, the applicant.
Represented the applicant in the main matter.
Mr. Udayan Chakravarti was there, and my lord, Udayan Chakravarti was there with Mr. Devraj Bhattacharya, my lord.
Who? But I do not find their name.
Yes, my lord, that's the whole difficulty with your main matter, my lord.
What difficulty?
My lord, names have not been given, the submissions are not recorded. Even the submissions are not recorded in the main matter.
No, the order, where is the order of the division bench?
My lord, division bench, your lordship will find at page 34 of the stay application.
Just a minute. Let us see who represented.
I was there, my lord, also in the matter.
Yes, Priyanka Gop was there. Now who has come? Now who has come?
My lord, I'm Ashok Gupta, my lord. I was there.
No, advocate and record.
My lord, this is N.P. Gupta. He has filed the Wakalatama.
Where is your Wakalatama?
It has been filed, my lord.
Can you give me the filing number?
আরে নাম্বারটা কি
এই ওকালতনামা নেই তখন কিভাবে অ্যাপিয়ার করছে লিস্টে?
That was given to them.
No, it doesn't. কিছুই কোনো ডকুমেন্ট নেই কিন্তু রিভিউ অ্যাপ্লিকেশন হচ্ছে একটা এটার অ্যাপারেন্ট অফ দিল্লি কোর্টে সাবটেন্স করেছে সেগুলো শুধু আবার একটা অন্য বাকি রিসিভার করে দিয়েছে ওই ওটাকে আমরা অ্যাকাউন্ট করেছি সেটাকেই রিভিউ চাইছি রিসিভার ও যদি ইন পার্সন অ্যাপিয়ার করে অ্যাডভোকেটের জন্য কিভাবে করবে কিন্তু দেখুন না আমরা ইনক্লুড অর্ডারে তো আমরা না তা হয় আমাকে ইন পার্সন তাহলে অ্যাপিয়ার করতে হবে সেটা হতে পারে ফাইল করেছেন প্রিয়াঙ্কা গোপ বাট সামবডি প্রিয়াঙ্কা গো এখানে কে করছেন এখানে তো উনি অ্যাপিয়ার করেছেন ওকালতনামা ওনার হয়ে কে ওকালতনামা দিয়েছেন প্রিয়াঙ্কা গো প্রিয়াঙ্কা গো কি প্রিয়াঙ্কা ওকালতনামাটা কে শুধু ওয়ান নির্মাণ এটা কে কি এক্সিকিউট করলে দেখো এইটাও দিয়েছে রিসিভার না তাহলে হবে না তাহলে ইনাকে দিয়ে মামলা করতে হবে এই ভদ্রলোক এই গ্রুপটাকে ইয়ে করাতে হবে
এটা প্রিয়াঙ্কা গুপ্তা কিংবা এই নরেন্দ্র পদ গুপ্তাকে দিয়ে মামলা person execute করে। ওর এত হিজ অ্যাক্টিভ ফর যদি ফাইনাল নিজে আগে করতে পারে এখানে কোর্ট অফিসে চ্যালেঞ্জিং হিজ অর্ডার অফ রিমুভাল ইভেন যেটা আমরা সেটা করি চাইতে হয় আর অথবা যদি ও এক্সিকিউট করে তোমার করে না তাহলে লয়ার জাস্ট আপনি জানতে পারেন ক্যান্সার বোকানো থাকবে
No, I'm still I'm an advocate. I'm still an advocate, my lord.
I'm asking you that a person who has given an authority by executing a wakalatnama to a lawyer,
Your lordships.
can he act as a senior counsel or a lawyer engaged by a junior or an advocate and
Your
record
lordship. My lord, this has
who
been,
derived authority from the same person?
my lord, is now for,
One can act in person, I can understand.
my lord.
But as a lawyer,
As a lawyer, I am
to
appealing, my lord.
understand under the
My lord, I have
Advocates
got
Act-
the powers,
under the
instructions from the,
Advocates Act, whether that is permissible.
my lord, there is no restrictions for me to act as an advocate, my lord. I have been instructed by the advocate on record to appear in the matter.
Who has given a power to the advocate on record?
My lord, the receiver has given. At the
Correct.
time being, your lordship will,
If the receiver has given a power and the advocate who is arguing the case is a receiver, can he argue as a counsel?
my lord, my lord, in my respectful submission, my lord,
Under 3 Rule 2 then has to be erased from the Code of Civil Procedure. Advocates Act has to be revamped, revisit, and to be amended as fully.
my lord, I have,
Everything has to be done.
my lord, I have not considered, my lord, receivers do mention the matter on behalf of the client, my lord, in respect of
no
which he
client.
has receiver.
Receiver does not hold the client. The receiver, as we know, is an officer of the court. The property over which the receiver is appointed
Lordships.
is in custodia legis, meaning thereby under the custody of the court.
Lordships.
Can the receiver, without any permission taken from the court, file any litigation?
My lord, I do not know about this law. My lord, I do not know about this law, my lord, to be frank with your lordship, but
If
my
you
lord,
do not know the law, then I have to
Well,
remind you from 1967 Supreme Court till now.
lordships.
Then you'll have to remember that what is the authority of the receiver, what are the duties and responsibilities of the receiver, and what is the status of the receiver vis-a-vis the court.
My lord, today I'm an advocate, I'm not a receiver.
The advocate can appear only on a instruction or not instruction, the power given to him by an executant of the wakalatnama.
My lord,
Executant and the lawyer both happen to be the same
my
person.
lord,
Then can he appear?
my lord, the executant has given power to the advocate on record.
Correct.
Now, advocate on record has engaged me as an, my lord, under
Is there
instructions.
enough? Suppose an A filed a proceeding, forget about receiver, A filed a proceeding before the court by engaging a lawyer. A is coming up saying that I am a lawyer, I want to argue as a lawyer.
Your lordships.
I do not want to argue as a party in person.
Your lordships.
Correct?
Your lordships.
I have not understood the law. If you can enlighten me,
My lord,
because a person should not remain unattended without knowing anything or become, the blank throughout his life. Every day is a learning process.
your lordships.
It is better to correct. So please enlighten me because I have carrying a very wrong impression about the proposition of law. So if you can enlighten me, I
Malad,
will be indebted in this regard.
Malad, that I have to check the law, Malad. At the moment, I cannot tell the lordships, Malad, because Malad, Malad, the lordship can give me the permission to appear, Malad, as an advocate. That the lordship can give.
Can't give.
If it is required.
Can't give. We can't give because we consider the receiver as our officer.
Lordship.
If we want to have any clarification from the receiver, we will straight away ask the receiver to disclose the facts. But we will not permit the receiver to act as a lawyer.
Well, that I will have to check
Take
the
a
law.
side of one person because he is a neutral person. He is a neutral person. He is there under Order 40 Rule 1 to manage, administer, and take whatever steps to preserve the immutable property that is involved. Or if it involves a movable property, to protect the movable property. Apart from that, one cannot. That is what I wanted to, that's the wrong law I have learned. I wanted to correct.
I mean, not even I do not know, my lord. To be frank with the lordships, that I have to check up, my lord. My lord, I have to check out the law because this difficulty does not arise, my lord. I mean, in cases, my lord.
No, this is the
Yeah.
this is the thing which never happened in the judicial, the era. I would say,
My lord, it's of
ranging from the day of
My lord.
advent of the law having been imposed till now. I have
my
not
lord, my lord, have
Very unique.
with little knowledge I have, my lord.
Right.
Lord, I tell you, lordship, my lord, in my personal property, a receiver was appointed, my lord. He was a barrister, my lord, and he also appeared before the court, mentioned the matter on behalf of the party, my lord. And,
Never.
my lord,
He appears and mentions the court as a receiver because he wanted certain direction for preservation and protection of the property. That he can do. Receiver can take out an application for a direction from the court to do a thing or forbidding any parties to do a thing. I can appreciate it. It's for the purpose of administration and management. But taking a side of a particular party and then arguing as a counsel, please enlighten me. I do
my
not
lord,
know the law.
my lord, even I do not know the law on this point, my lord. Lordship
You
will,
have to face
my
the
lord,
consequences. Then
my
you
lord,
have to think about it.
my lord, your lordship will, my lord, this is the technical thing, your lordship will kindly leave it, my lord. My lord,
Let us see.
my lord, your lordship will, is a technical, my lord, thing, your lordship.
Whenever it's a rule of, I would say, the rule of equity. It's a rule of, I would say, the fairness and a transparency which should be brought into the judicial proceedings.
My lord, in that case, your lordship will give me some time, I will consider, my lord. But I was only submitting, my lord. My lord, urgent leaves are required, my lord. My lord, regarding the salaries have not been paid of the staff, my lord, for the last 6
The
months.
review application.
This is the review, and
An application is
this receiver has filed an application for.
I'm making an application.
This receiver has filed an application.
Why is coming, my lord?
Did not have to. When the court is
Yeah,
interacting.
sure.
Why you are interfering?
I am not interfering, my lord. I am not interfering, my lord.
Don't identify yourself with the client.
No, never, my lord.
I'm grateful.
You have seen the way it is being identified. I do not want that you should be there.
Gosh, I'm grateful.
When your turn will come, we'll ask you a question. Go before the court. Why the review?
My lord, review, my lord.
Why review?
My lord, it's regarding the order which has been passed by lordships on the 1st of October, my lord. My lord, I have taken several grounds in the review, my lord, memorandum of review, which I will place before lordships, my lord. My lord. Lordship will kindly see, my lord, my lord, may I take your lordship to the stay application because there are certain facts which are mentioned in the stay application which are not there in the grounds of review. So, my lord, only the stay application for the purpose of.
Then what does it mean? The stay application, certain facts not there in the ground of review.
My lord,
what should I?
My lord, in the grounds of review are legal grounds. Now, without the facts, my lord, it will not be able to, my lord.
Can a fact be corrected or can the facts be gone into in the review?
My lord, law.
Review is intended only on 3 grounds.
My lord,
as envisaged under Order 47 Rule 1.
No, my lord, my lord.
I do not know the fourth ground.
No, your lordship will kindly allow me to place the decisions, my lord. I put in a lot of this thing. I burned my midnight oil to find the decisions, my lord. My lord, today, my lord, review by a high court, my lord. Is under high court is the court of record. Is
215, I know.
my lord, in that case, what happens, my
Well,
lord?
what happened?
My lord,
I am also conscious of the judgment where it says that the High Court, the power to review is ingrained and inherent into the
Lordships.
into the High Court. No
Lordships.
difficulty.
My lord, if that is there,
But the review means review of everything. I'm
my
just asking.
my lord, the points, my
Or
lord,
on a very limited.
my lord, very limited ground. My lord,
No, not limited ground.
my lord, if suppose my lord, the decision has been cited, but it has not been
I can give you a judgment against you. It is not a review. It may be an erroneous decision.
My lord,
Not
I will satisfy your lordships, my lord.
not
I will satisfy your lordships. If your lordship will allow me to make submissions, my lord. I have suggestions on this point, my lord. Every point I will satisfy your lordship. Today I have come with several decisions. My lord, if your lordship will see that, my lord, let me place the grounds.
taking a risk of appearing as a lawyer, then we'll have to make certain comments on that. If
My
you
then your
approach
lordship will give.
I'm warning, I mean, giving you a just indication. We will not prevent you, but we will make certain observations.
My lord, that observation will affect me as an advocate, my lord.
I do not know which way
That
it will go.
observation will be not in my favor.
You'll have to then say something.
Yes, my lord. My lord, the
Up to
lordship
you.
will, can they allow me to check up the this thing law on this point, my lord, and I'll come back before lordship. Only relief which I want at the moment.
Two things. First thing is your authority to appear as a lawyer. If you want a time, we can give you a time to ponder
Lordships.
upon the issue.
Lordships.
If you want to argue on merit, we are ready to hear you on merit.
But your lordship will pass
Whatever
certain
the
observations.
consequences that would come therefrom, we will
My lord,
pass
then
it.
your lordship will give me time. I'll check the law and come before lordship. My lord, only my lord, I am submitting. We are lordships, my lord.
It's your baby. You have to nurture him.
My lord, 6 months salaries have not been paid. My lord, electricity, my lord, there is a temple. My lord, even the bhog, daily bhog, to
My
Lord
lord,
Krishna,
may
Lord,
I-
that is being not paid.
these submissions never made before the trial court.
Yes.
What at a time?
My lord, I will check the law and come before lordship, my lord.
Come back.
1 week.
1 week. Come back.
Only one thing, my lord, because I have to say this, that is why I am saying. Otherwise, I would not have wasted the precious time of the court. My lord, first of all, your lordship knows Woodruff on receivers, where it is clearly written an application for discharge, receiver has no audience. Number one. Number two, I have brought Supreme Court judgment saying that in the guise of a review, you cannot have an appeal going on. That your lordship has said. Now, my lord, the only question is a person who comes to court and decrepitates his position in this way undermines not only the dignity of the court, but the management of the properties at stake. My lord, I am beseeching your lordship in appeal. Your lordship has all the powers of the suit court. My lord, kindly, my lord, put a
regular appeal.
it is not a regular appeal, but
review.
it is a review. My lord, then
Appeal is already.
we will take, my lord, but only difficulty, my lord, is in this way, my lord, the property is sure for dissipation.
Even the bank account operation has been stopped by the learned trial
The
court.
trial court has stopped it. We cannot deposit our checks, my lord. The rents we can't give. The suit court handling financial matters at the wake of an application which was before the suit court. Now, this is the situation of his reputation, and he's arguing like a
My reputation, he will not challenge my reputation.
Very exceptionally, my lord. My lord, this is one of the rarest case where the receiver has made an application for recusal before the court below of the judge appointed him as
Let
a
him show the application. My lord, let him show the application.
release the part heard before the regular bench.
It's not only his respect, my lord, it is the respect of the entire bar.
Let him show the application.
I want to hear my lord.
Come on the next day.
Yes.
I will.
Let him
My lord has indicated.
go.
I will.
Let him decide what can be done. Let him come up.
And he is telling about Krishna Bhog. Bhog Sheba is not being done. And application for recusal and the court of learned
No other matter.
He's
what is
saying, he's bothered about his reputation. What about ours?
A question arose of the hearing when
Yes.
mouth was already gone. So it had to be revamped.
Let it come, my lord, let it come through a process of learning from your lordships, my lord.
Mullah, we learn every day.
I'm deeply obliged.
I'm grateful, Mullah.
ফার্স্ট করে দিই আগে ফুটে তারিখ আছে
বুঝবেন
চলে